HOA President Karen Whitmore called 911 and reported a burglary while I was carrying boxes into my own ranch. She stood in my driveway, pointing at me like she'd already decided I was guilty. 10 minutes later, her story was dead. The deputies had my deed in their hands. My name matched the county record, and the burglar Karen wanted removed was the legal owner of the property. She should have stopped there. Instead, 3 days later, she came back with an $850 HOA fine and threatened to put a lien on my ranch. What Karen didn't know was that I'd spent 30 years practicing real estate law. I knew exactly what a valid lien required, and I knew hers wouldn't survive. If you enjoy watching bullies get beaten by the law instead of louder bullies, subscribe. Because once I started reading Karen's paperwork, I discovered my ranch wasn't the real story. She'd been doing this for 9 years. One of the deputies looked from the deed to my driver's license, then back toward Karen. "Sir, how long have you owned the property?" "Closed yesterday." Karen folded her arms. "That doesn't mean he can just move in without notifying the association." The deputy gave her a look I'd seen hundreds of times in courtrooms. The look people give someone who has just answered a question nobody asked. He handed the deed back to me. "Everything checks out. He owns the property." That should have ended it. It didn't. Karen stepped closer and tapped a folder against her palm. "This community has procedures. New residents are required to coordinate move-ins with the HOA." I looked at her. "Which procedure?" She stared at me for half a second too long. Then she said, "You'll receive the documents." That pause told me more than her answer. I'd bought the ranch because I wanted quiet. After 30 years of contracts, title disputes, boundary fights, easements, liens, and people threatening lawsuits over 6 inches of dirt, I was done with conflict. The ranch sat on a little over 12 acres at the edge of the development. Old fencing, a weathered barn, a long gravel driveway, and enough distance between houses that I could drink coffee on the porch without hearing somebody else's television. It was supposed to be retirement. Karen apparently had other plans. Before leaving, one deputy pulled me aside. "She call you before she called us?" "No." He nodded. "Might want to document that." I almost smiled. I was planning to. Karen heard me. For the first time that morning, the confidence slipped off her face. Only for a second. Then she walked toward her white SUV and called over her shoulder, "You'll hear from the board." She was right. 3 days later, at 8:17 in the morning, Karen returned to my ranch with another board member and a white envelope. Printed across the top were the words, "Notice of violation, $850 DUE." Underneath was a rule I was almost certain did not exist. I waited until they left before I opened the envelope. The violation was labeled, "Unauthorized move-in activity." According to Karen, I had failed to schedule my move through the HOA, failed to submit a vehicle list, and allowed a moving truck to remain on the property without approval. Total penalty, $850. There was only one problem. The notice didn't cite a bylaw, no section number, no covenant, no page, just a sentence saying the fine had been issued under the association's Community Compliance Authority. That phrase bothered me. So I went inside, made coffee, and opened the stack of governing documents I'd received at closing. Declarations, bylaws, architectural guidelines, rules and regulations. I read all of them. Then I read them again. There were restrictions on permanent commercial vehicles. There were rules about construction debris. There were even limits on where residents could store recreational trailers. But there was nothing requiring board approval to move into your own home, nothing about submitting a moving schedule, and absolutely nothing authorizing an $850 penalty for failing to do either. I placed Karen's notice beside the bylaws. 30 years in real estate law had taught me something simple. When somebody claims authority, don't listen to how confidently they say it. Find the sentence that gives it to them. Karen hadn't given me one. Then I noticed something at the bottom of the notice. Failure to pay may result in additional enforcement, including a lien against the property. That was when I stopped treating Karen like an annoying neighbor, because she had just threatened my title with a rule I couldn't find anywhere. The next morning, Karen came back. This time she wasn't alone. A thin man named Douglas Reed stood beside her holding a leather folder. Karen introduced him as a board member, although from the way he avoided eye contact, he looked more like a witness who already regretted being there. Karen handed me another copy of the violation. You have 5 business days to pay. I looked at the page. Show me the rule. Her expression tightened. We've already explained this. No, you've explained what you want me to do. I'm asking where the board gets the authority to fine me $850 for moving into my own house. Douglas looked at Karen. Karen didn't look at him. Instead, she stepped closer. If you choose to be difficult, the association can escalate enforcement. How? Additional fines. Legal fees. A lien if necessary. I let the silence sit there. Then I asked, You're threatening to place a lien on my ranch over this? I'm informing you of the consequences of non-compliance. There it was. Clean. Clear. In front of a witness. I folded the notice once and slipped it back into the envelope. Karen seemed disappointed. I think she expected anger. Maybe shouting. Maybe a threat she could quote later. Instead, I said, Could you email me everything you just explained? She smiled. Of course. That was the first genuinely useful thing Karen ever did for me. By noon, her email was sitting in my inbox, repeating the fine, the deadline, and the lien threat almost word for word. I printed it, dated it, and placed it in a new binder. On the spine, I wrote one word, HOA. Karen thought she had started collecting penalties. I had started collecting evidence. That binder wasn't something I created because I wanted revenge. It was habit. For 30 years, I had practiced real estate law. Boundary disputes, easements, title defects, bad liens, owners who signed documents they never read, associations that sometimes confused tradition with legal authority. I had retired because I was tired of all of it. I wanted mornings on the porch, work in the barn, and enough land around me that nobody needed my permission to breathe. Karen was dragging me back into the exact world I had left. So I treated the situation the way I would have treated a client's case. No arguments, no angry phone calls, just records. I saved every email. I photographed every notice. I wrote down dates, times, names, and exact words while they were still fresh. I requested the incident number from the morning Karen called 911. Then I created a timeline. Day 1. Burglary report. Day 3, unsupported $850 violation. Day 4, written threat of a lien. 3 separate actions. All from the same person. All based on authority Karen still hadn't shown me. And there was one more thing I noticed. The violation notice carried a sequence number. It wasn't number 1. It wasn't even close. I stared at it for a few seconds. Karen hadn't invented this system for me. She had been using it before I ever bought the ranch. The question was how many people had already paid because they were too intimidated to ask the same thing I had. Show me the rule. 2 evenings later, someone knocked on my door. Her name was Elena Alvarez. She was 72, lived alone, and had been in the neighborhood for almost 14 years. She laid 6 violation notices across my kitchen table. One was for a wind chime. Another was for 2 flower pots Karen claimed were inconsistent with neighborhood aesthetics. The third fined her because her grandson had left a basketball hoop near the driveway for a weekend. I pulled out the bylaws. Did Karen ever show you where these rules were written? Mrs. Alvarez shook her head. She said the board had discretion. How much did you pay? Her eyes dropped toward the table. Almost $2,000. That bothered me more than the fine Karen had sent me. Not because mine was smaller. Because Mrs. Alvarez had paid simply because she believed she had no choice. The next afternoon, Miguel Garcia stopped by. His family had been fined over landscaping Karen called non-compliant. Then Tom Henderson brought me notices involving a trailer parked behind his own garage. Different homes, different violations, same phrases. Community standards, property values, board discretion, and none of them could show me the actual rule they had supposedly broken. I started comparing their notices to mine. Same formatting. Same vague language. Same threats about late fees and liens. Some went back years. That was when the problem changed. Karen wasn't just trying to scare the new owner at the edge of the neighborhood. She had built a system that depended on one assumption. Nobody would make her prove she had the authority she claimed. Mrs. Alvarez looked at the binder in front of me. Can you do something about this? I didn't answer immediately. Because I had just noticed another pattern. Karen's signature appeared on nearly every notice. And according to the HOA records I received at closing, she had been president for 9 straight years. 9 years. That was a long time to hold power in an association that supposedly held elections every year. So that night, I stopped reading violation notices. I started reading election records. The records were almost too clean. Every year, the minutes said the same thing. No additional nominations received. President re-elected without opposition. Karen Whitmore. Again. And again. 9 years in a row. At first, that wasn't proof of anything. People run unopposed all the time. Then I found the nomination section in the bylaws. Any homeowner in good standing could nominate another eligible resident before the annual meeting. The association's own documents required notice of that process. So I asked Mrs. Alvarez if she remembered receiving one. No. Garcia didn't either. Neither did Henderson. I went back through the meeting packets I could get my hands on. Dates, agendas, election notices. Karen always announced the meeting. What she rarely explained was how anyone could challenge her. That was the trick. She didn't have to cancel elections. She only had to make everyone believe there was nobody else to vote for. I added another tab to the binder. Elections. By then, I had enough to know Karen's authority wasn't nearly as solid as she wanted people to believe. But I still wasn't planning to take her down. I wanted the fine withdrawn. I wanted her off my property. And I wanted to be left alone. Karen could have given me all 3. Instead, she escalated. 6 days later, I opened my mailbox and found a certified envelope related to a filing against my property. I read the first page once, then a second time. Karen had done exactly what she threatened to do. The association had recorded a lien against my ranch. A lien isn't just another angry letter. It attaches a dispute to the property itself. It can complicate a sale. It can interfere with refinancing. And it can scare an owner into paying money they may not actually owe. That's exactly why the procedure matters. I laid Karen's filing beside the association's own collection policy. Then I found it. Before the HOA could take that step, its own procedure required written notice and a 30-day opportunity to resolve the alleged debt. I checked my mail records. Nothing. My email. Nothing. The certified correspondence I had saved. Nothing. Karen had gone from an unsupported fine to a recorded lien without completing the process her own board claimed to follow. I read the filing again. Then I smiled for the first time since this started. Not because the lien was harmless. It wasn't. But Karen had finally stopped making vague threats. Now she had put her decision into a formal record, with dates, signatures, and a paper trail. I contacted the appropriate records office, not to argue, just to confirm exactly what had been filed and when. Then I obtained a copy. I made 3 more. 1 went into the binder. 1 went into a separate file. The 3rd stayed on my desk. I didn't call Karen. I didn't send her a threatening letter. And I definitely didn't tell her what she had missed. 30 years of legal work had taught me another useful lesson. Never interrupt someone while they're documenting your case for you. Karen apparently mistook my silence for fear. 2 days later, another email arrived. This one went to 12 people, including board members and several neighbors. Karen described me as an aggressive occupier who refused to respect community authority. Then she suggested my ownership of the ranch might still need to be clarified. I looked at the deed sitting 10 feet away, then at the email. She had already called police on the legal owner. She had already fined him under a rule she couldn't produce. She had already recorded a lien without following her own association's process. And now she had decided to put her version of my character in writing. I saved the original email, printed a copy, and placed it behind the lien. Karen still thought she was building a case against me. She had no idea she was building mine. Then Mrs. Alvarez called. Karen had contacted her too. She wanted residents to attend a special meeting the following Thursday. According to the notice, the board would discuss continued enforcement action against a non-compliant property owner. Me. I read it twice. Karen wasn't backing away. She was trying to get the board to endorse what she had done. Publicly. That changed things. Until then, I had been collecting evidence mostly to protect my ranch. Now Karen was giving me a room full of witnesses. I called Alvarez, then Garcia, then Henderson. I didn't tell them what to say. I only asked each of them to bring every violation notice, payment record, and HOA letter they still had. By Wednesday night, my binder had grown thick enough that it barely closed. The first tab said ownership. The second said fines. The third said lien. The fourth said elections. And behind all of them were years of notices Karen assumed nobody would ever compare side by side. The next evening, I carried that binder into the community clubhouse. Karen was already standing at the front of the room, smiling. She thought the meeting was about me. The clubhouse was nearly full. Karen stood behind the board table with Douglas beside her and the HOA attorney at the far end. She looked completely comfortable. When I walked in carrying the binder, she glanced at it and smiled. "Glad you decided to cooperate." I took a seat in the second row. Then I noticed Mrs. Alvarez behind me. She had her notices in a grocery bag. Garcia was holding a folder. Henderson had brought 3 years of receipts. Karen hadn't noticed them yet. At 7 sharp, she called the meeting to order. For the next 5 minutes, she described me as a homeowner who had repeatedly refused reasonable community compliance. She mentioned the $850 fine. She mentioned the lien. And then she made her biggest mistake. She asked the board to formally approve further legal action against me. The HOA attorney leaned toward her. "Karen, before the board votes, we should probably let the homeowner respond." She looked irritated. Then she turned toward me. "You have 3 minutes." I stood, carried the binder to the front table, and set it down. "I won't need 3. Karen smiled again. I opened the first tab, ownership. Then I slid my deed across the table. Before we discuss what authority this board has over me, I said, I'd like to establish exactly what property we're talking about. The room went quiet. Karen stopped smiling, and we had only reached page 1. She looked at the deed but didn't touch it. We already know you purchased the property. Good, I said. Then we can stop describing my ownership as questionable. A few people shifted in their seats. I opened the next tab. Fines. I placed the $850 notice beside the deed. This says I violated the association's move-in procedure. Karen nodded. You did. Show me the procedure. She frowned. It's part of our community standards. Which section? Karen reached for the bylaws. She flipped through several pages. Then several more. Douglas leaned toward her. Nothing. I slid my copy across the table. I've read them twice. There is no rule here requiring board approval before an owner moves into his home. Someone in the back whispered, Then what was the $850 for? Karen's face tightened. The board has discretionary enforcement authority. That authority still has to attach to an actual rule. I opened the third tab. Lien. This time the HOA attorney sat forward. I placed the recorded lien in front of him. After I refused to pay the unsupported fine, this was recorded against my ranch. Karen immediately said, because he ignored repeated notices. I looked at her. No. I received a fine. Then I received threats. What I did not receive was the 30-day collection notice described in the association's own procedure before this filing. The attorney picked up the document. He checked the filing date. Then he looked at Karen. Where's the pre-lien notice? Karen hesitated. We communicated with him multiple times. That wasn't my question. The room changed. It was subtle. Until that moment, Karen had been running the meeting. Now her own attorney was questioning her. I opened another section of the binder. Then there's the email. Karen's head snapped toward me. I handed copies to the board. The room went silent as they read her description of me as an aggressive occupier whose ownership might require clarification. I waited. Then I said, You sent that after law enforcement had already verified my deed. Karen crossed her arms. I was protecting the community. From the owner? A few people laughed. Karen didn't. Then Mrs. Alvarez stood up. Her hands were shaking. Her voice wasn't. What about mine? She carried her grocery bag to the table and pulled out 6 notices. My wind chime, my flowers, my grandson's basketball hoop. Show me those rules too. Garcia stood next. Then Henderson. Within 2 minutes, the table was covered in notices. Different dates, different homes. The same language. Karen stared at them as if she had never expected those pieces of paper to exist in the same room. That was the weakness in intimidation. It works best when every victim thinks they're alone. I opened the final tab. Elections. 9 years, I said. Karen looked at me. 9 years as president. Every set of minutes says there were no opposing nominations. Because there weren't. Then perhaps you can explain how residents were supposed to nominate someone. I turned the bylaws toward the room and pointed to the nomination provision. Mrs. Alvarez spoke first. I've never seen that. Neither have I, Garcia said. More voices followed. Karen looked toward the attorney. This is ridiculous. We've always followed procedure. He didn't answer immediately. He was reading. The lien. The bylaws. The notices. Then the email. Finally, he removed his glasses. I think the board should suspend any further enforcement action tonight. Karen stared at him. Excuse me? And we need to review the lien before anything else happens. I am the president. Yes, he said quietly, which is why I strongly suggest you stop talking. Nobody laughed that time. Karen's face went pale. For 9 years, she had controlled that room because everyone assumed she understood the rules better than they did. All I had done was put the rules on the table. The attorney closed the lien file. No vote tonight. Karen looked around the room for support. Douglas wouldn't meet her eyes. Neither would the other board members. Mrs. Alvarez was still standing. So was Garcia. So was Henderson. And for the first time since I met her, Karen had nothing to say. I closed the binder. The meeting she had called to put me in my place had ended with her own board afraid to follow her any further. The board met again 48 hours later. Karen wasn't invited to lead it. The HOA attorney requested an independent review of the lien, the fines, and the notices residents had brought to the meeting. By Friday afternoon, the $850 fine against me was suspended. The board began the process of releasing the lien. And new enforcement actions signed by Karen were frozen pending review. She called me once. I let it go to voicemail. Her message lasted nearly 4 minutes. She blamed confused procedures. She blamed previous boards. She blamed residents who misunderstood community standards. What she never said was, I was wrong. The real change came when Douglas knocked on my door that weekend. He looked exhausted. The board asked Karen to step aside while this is reviewed. Did she? Not voluntarily. I nodded. That sounded more like her. Then Douglas said something I hadn't expected. We found more notices. I looked at him. How many? He glanced at the folder in his hands. Enough that we're reviewing 3 years of fines. That was the moment I understood the meeting hadn't just stopped Karen from coming after my ranch. It had opened every file she thought nobody would ever question. A week later, Karen submitted her resignation. No speech, no apology, just one paragraph emailed to the board. 9 years of control ended in 6 sentences. The lien was formally released 11 days later. I kept the stamped copy. Not because I expected to need it again. Because after everything that had happened, I had developed a healthy respect for paper. The board's review went further than I expected. 3 years of questionable fines were reopened. Mrs. Alvarez got every dollar from her wind chime and landscaping penalties credited back. The Garcias had their violations removed. Henderson stopped receiving threats over the trailer behind his garage. And for the first time in years, residents received a notice explaining exactly how to nominate someone for the board. The next election had 4 candidates. Nobody ran unopposed. A month later, I drove past Karen's house and saw a real estate sign in the front yard. For sale. I didn't stop. I didn't celebrate. I had never wanted her house, or her position, or revenge. I had wanted to unload my boxes, repair the old barn, and drink coffee on my porch without somebody telling me I needed permission. By fall, that was exactly what I was doing. Mrs. Alvarez would wave when she walked past. Garcia helped me replace part of the west fence. The HOA still existed. There were still rules. The difference was that now people actually read them. Karen had believed authority came from sitting at the head of a table long enough. 30 years in real estate law had taught me something different. Titles matter. Rules matter. But when someone uses either one to threaten your home, ask to see the document. Then read every word. Because Karen called the cops thinking a stranger was stealing from a ranch. She never imagined the owner would be the man who finally opened her files. And once we did, 9 years of power disappeared on paper.